address your lordship. I have gone through the counter files. Lordship may just remind my lord that shifting of the shop passed by the collector besides the issue of jurisdiction. On facts also, your lordship will find the counter in fact supports my case.
Counter in fact?
The counter supports my case.
Oh.
That's right. That is what your lordship will see page 2 of that counter. Page 2 paragraph. Paragraph.
So this is what you were saying, that this shop was operating since last 4 decades. Is that matter?
That matter.
Okay.
And they have said here, but para 5 from the 5th line, he said IFL shop functioned uninterruptedly for more than 4 years.
So it has already been renewed till March 26.
Yes, yes. From renewal, it has completed 4 years. From last renewal.
Your renewal of the license is still there.
Yes. For 25-26 also renewed.
Correct.
That's what they have admitted here.
Yes, that is there.
For the year 25-26.
Then what is the difficulty here?
The difficulty here is that they themselves have produced the format notice for.
Oh, this is a 5/6/2025 order?
Yes.
Where is that?
But page 11. But private PC of the view that this is
just 1 minute.
Right.
Just to recapitulate the facts.
I'm so sorry. Beg of course. Kindly say Annexure 1 page 11.
Oh. So the superintendent of exercise directed to find a suitable.
So page 3, last but one paragraph.
That
is the whole objection.
What?
Page 3 of the counter, last but one paragraph. It may be noted there.
Yes. But what I am trying to tell you, lordship, is before the last renewal, they admit to have issued a notice inviting objection. Now, all throughout there was no objection. Even there, as per their notice, there was no objection. Can you see their notice? Case K. Before renewal, this was the notice they have given inviting objection. Last date was 7/1/25. Now,
where page?
Page
10 of the counter.
Page 10 of their counter.
Okay. Answer 84.
Okay.
Any person residing within the said local.
Yes, are invited.
Yes, invited by 7/1/25.
And there was no objection which was
There was no objection. Admitted position is this. They have admitted in their counter. Now, the rule say that after expiry of the last date, no objection shall be entertained. That is rule 33. And it's 31. I'm so sorry. 31. 33. Of Odisha Excise Rule.
2000?
2017, Rule 33, Sub Rule 2.
Rule 33.
33. Sub Rule 2. This is the procedure for the
Summarily rejected.
the objection was filed 4 months thereafter.
After that,
Yes.
then it has to be summarily rejected. Now again, after the further renewal in the month of March.
Yes, that's the point.
Yes.
And your lordship also will be prior this is satisfied that no reasons is assigned. Your lordship indicated that get the judgments as to reasons, but I have got those judgments. Yes, para 40, 41, 42. This is that case of shifting of Victoria Memorial.
You have brought the incident of Calcutta.
Yes. I was incidentally, I came across that incident of Calcutta.
Can it be shifted?
I think
the Victoria Memorial cannot be shifted.
No, it's question of that is what the Honorable Supreme Court says that you have not assigned any reasons.
Actually, I think the problem was that there was mass commercial activities which was going around the Victoria Memorial, which is a monument. So that really affects the marbles which are used. And they were blackening or something that was coming up. So
like plasma.
So that was the issue which was raised to remove those commercial activities. And there was an expert body which was constituted and submitted a report which says that yes, there is some kind of things. going on. So there was a direction for removal of those
Those. So-
commercial activities that you can't use the oven or something.
It's-
So that went to this epic.
That had led to be the wrote para 40, 41 and 40. These will be the heartbeat of every country.
So invariably, I use that
Yes.
heart and soul of an order.
Yes, an order. Now, the collector has passed the order. I say that collector also had no jurisdiction without an approval from the commissioner. Rule 53 says. And fourth point is, I have not applied for shifting. Unless I apply for shifting, collector cannot compel me to shift. Of course, subject to the objections are considered.
Correct. Do you think that Rule 31 applies in case of renewal?
Notice of proposal. Yeah, but this initiates from the 31 is the beginning.
That is what I was just thinking,
Yes.
that whenever there is a any decision to open a shop,
Right.
then for the first time, then I think Rule 31 and Rule 33 has to be considered along with the Rule 31,
31.
because sub-rule 1 talks about Rule 31.
Yes. Before grant of any license.
No, all objections and suggestions referred to in Rule 31 means
Yes, Lord. Yes.
for the first time,
Deeply obliged. Yes.
not at the time of renewal,
But renewal also, they say, before
where
they say that they say.
where is that provision? Where is the chapter dedicated for renewal?
But renewal, it's not under
There is
the
no-
act.
there is no
It's
check.
based on policy. In terms of section 90 and
So that
91.
is why I was just thinking that if that being the position, Rule 31 or 30,
Right.
these are all 30 talks about the proposal
But
or the
they
preparation.
They consider every renewal as a grant of license and accordingly issue a public.
How? Under what provision?
37 of the Act members.
37.
But this is
Proposed. This is what I am saying. Proposed.
Before expiration of every period for with existing license, for every year before the expiration of existing license, new notices are issued and accordingly objections are called for.
Expressing doesn't speak of renewal, grant of license.
Yes, madam.
Look at the language. Propose to grant retail sale of source. This applies for.
No. Before the expiration of the period, the opening sentence has to be read.
Yes.
For which existing licenses, that means a renewal.
Right. Next period of settlement.
So renewal is construed to be fresh license as if it is granted fresh.
So high.
So that is a consideration again.
That's a
Consideration again whether to renew or grant
Every
grant
time
the
the process
permission.
is initiated from 1st of November.
I borrow the expression from the Supreme Court judgment,
Right.
where the word renewal has been defined and explained.
Unsaid it.
So they have dissected the word renewal into two compartments. One is a another is a renewal. So the apex court interpreted it means again,
Then renewal means.
and renewal means afresh,
Fresh.
something which is new.
Yes.
So it is really a grant of a fresh.
Grant of a license.
So that is what is borrowed.
37. I'm so grateful to. She has got it out 37.
37. That talks about this. Yes.
Without adhering to the marginal note,
Hey,
marginal heading. Nothing. Nothing.
And 37 is the repository of these rules.
Which one?
37, as your lordship see section 37,
That is what it
that is the
says.
repository of it. If your lordship see part 2 of these rules,
The
it starts
substance,
from rule 30. Kindly see, rule 30. Part 2 of this 2017 rules. On or before 20th of October, collector shall prepare a list in Form 6 showing what licenses or exclusive privileges proposed to be granted for so including liquor, mobile flats, so of on some vendors premises for the next year of settlement.
Right.
Then
So
provided
that really shows about it, because 33 which you are referring,
Right.
that contemplates both 30 and 31.
Completely.
So it is renewal also that is coming within that. There was confusion in my mind, that's why I just
No,
invited.
it's up.
And thanks to her that she has invited section 37.
I have expressed my obligation to her also.
True. So we have to quash it.
One ground which is mentioned in the counter affidavit, one page, my lords, I will just refer. The relevant provision which is mentioned in that portion is not applicable because it applies to opening of a new shop.
Which one?
Page 7, my lords.
Yes.
Second paragraph, as observed from the inquiry report, my lords, that
Yes.
if I may read this portion only, my lord.
This is the omnibus,
Yes, my lords.
very omnibus. There is nothing which would, the
I think
difficulty
this
I
is-
tell you, the nuisance can be a ground for, is there any ground for nuisance as a
We
ground?
said the closure is there, section 26.
20?
Closure is there.
Rule 45.
One second. Rule 45 is the. Closure is collector power, section 26. The plenary power of the collector.
Yeah, that is a power to close
Yes,
on the ground of nuisance.
yes.
So, but it does not require any shifting. Shifting is a different concept.
Shifting is as per rule 53 of the.
So that is not coming within that. If 37 is to be read, and then rule 33 is to be read in a proper manner, then in that event, only on an objection you can't.
Renewal, at the time of renewal only that could be taken into consideration.
Correct.
Yes, ma'am.
Absolutely.
But that cannot be done in the midway.
Yes.
The provision, they, in the counter, we have tried to rely upon is rule 53(5), my lords. Whether.
What is the power of sentiment?
that is the
First
power.
thing is that power of the collector,
Yes,
but
ma'am.
shifting, the power to shift must be exercised within the law.
Yes.
That he cannot.
And also,
Rule
section,
53. Rule 53.
Rule 53, I've seen 5. That power is given.
Let's see.
But that has to be read
Begins
with
from the
one.
one. Any person intending to obtain a license under the act or a person
Oh,
selected.
That is
Ah.
sub-rule ones.
This has to be read in conjunction with the section
Sub.
37 also. So you can't say. So we have to harmonize those provisions. So we are not going into that aspect. We are simply going by section 37 and the rule 30, 31 and 33. As wrong application of 53(5).
Right.
And temporary closure is rule 20,
Section 20.
section 27.
That occasion has not arisen.
Oh, yes, what he can do is only on the ground of nuisance because of
Yes.
this
This was
objection being taken here.
counter stand being taken in the counter, they could have.
Correct. The instant writ
One just suggestion to my lordship, I was for it, addicted with this number. So that, this several your lordship has said in the aspect of.
That is within the premises, sir.
Lordship says, I'm sorry, Lord, 37 is imported to section 43, which says made applicable to other subject.
43 is in, I have seen that. If you look at the language,
I'm sorry, Lord.
I have seen that. If you come, I have seen that 43 also.
No.
If you read that, application of 37 to 42 to the license for the retail sale,
Right.
other than the spirit. And this is the spirit. I have seen that, other than the spirit, not contemplated. You are selling a spirit or tari. These are the two. Anything beyond spirit and tari, I think that should be applicable to bhang.
Yes. Bhang.
Sir, I have a hawk eyes.
And my lord's notice, that's all. It's fine. I'm in expert.
I noticed and then I thought, then a language was other than. So that really creates.
Yes, that has kept the exception.
And 37 talks about spirit or tari.
Also. Conjunction.
Spirit or tari.
Yes. Grateful.
The Government of India undertaking.
Review of which order?
What I'm challenging the order of the.
Not challenging, you wanted a review.
Sorry, Madam.
Not challenging, you wanted a review.
Review, yes, madam.
Yes, review of a order dated 18/6.
Review of the judgment rendered by this honorable court
18/6.
in writ appeal number.
Oh, 18/6 order.
620.
But that is,
Yes.
be fast,
Yes,
Mr. Mukherjee.
yes, Lalit. Now, Lalit, essentially the challenge is on two count. Where in my humble submission to your lordship, the facts and law has been wrongly appreciated.
Can it be a ground?
That's an error apparent on the face of the record because
Wrong. The only thing is, suppose the law is applied,
yes, Lalit.
that may be erroneously applied.
No, it's not been erroneous. It has been erroneously appreciated. The fact has been erroneously appreciated for which a wrong law has been applied.
Oh,
A law which is not applicable to in my case. Your Lordship may kindly bear with me for a minute, my lords. Your Lordship kindly sees page para 4 at page 28 of the appeal memo. This is a part of the judgment where two dates are very important. Para 4
of the judgment?
of the judgment
Yes.
at page 28. Your
Yes.
Lordship sees the work is fabrication, erection, painting, etc. of structural steel work.
Yes.
Now, pausing here for a minute, my lords, I'll again come back to this. This is out and out of works contract.
So,
I'll come to that. With power plant so and so, various amendments to the original work order dated 11/6/2010 was made. The last amendment being made on 25/6/2015. This date is very important. 25/6/2015. And my lords, the petition at the claimant came to be registered as an MSME on the 18th of December 2015, after the last work order was issued. So, my lords, the work order or the purchase order in this case contained certain terms and conditions. By virtue of this incorporation as a MSME, these conditions are sought to be overridden by the conditions of the MSME Act.
We said that the purchase one fructifies.
Sorry, Mother?
The purchase fructifies on the date of supply. being complete.
I'm on the contract.
So that is what we heard here. So by then, if he is registered,
No,
then his right accrues.
no,
Or his right,
that is the point.
matures.
I'm trying.
That is what held, we have held.
Yes, your lordships have
Yes.
held that. Now, my lord, that is, my lords, according to me, because what your lordships held was that since the supply was after the registration, some of the supplies were after the registration, he would be entitled to the benefits. My lord, that can only happen. That can only happen if Section 62 of the Contract Act comes into play. The previous contract of the purchase order gets novated by the subsequent change in status of the claimant. Now, the change in status of the claimant was never communicated to the respondent. So, my lords, I continue to do business or receive supplies from the person who had entered into a contract with me and was not an MSME unit. Had I known that he is an MSME unit, maybe I would have stopped the supplies. I would not have incurred the
But that
penal or the punitive.
That was not the argument then.
Well, this is a pure
Perhaps-
question of law. man.
Perhaps now you are
Oh, no.
making up your
This is
case.
pure-
You are not arguing counsel, then,
No, I was.
Huh.
I was.
Then,
So-
I was not the arguing counsel. I have come in at a later stage.
then AIR 1997 Supreme Court, page 1007.
I'm aware of that, but since it's a pure question of law,
Can it be?
yeah, I am.
The Supreme Court has in very, very strong words.
Let me argue, my lords. What was
I have,
argued before your
in
lordship?
one first paragraph of that judgment, you should read.
My lords, I am conscious of that judgment. I know what my limitations are, but I venture.
There,
to
the
make this
Supreme
point.
Court has deprecated the filing of the review that through our different counsels and then arguing a case that this point was not considered, that point was not considered. This could not have been done. All these things the Supreme Court deprecated and says that no, it should not.
I am absolutely. But since it's a pure question of law, I will venture to raise it. Now,
Hey.
what was raised?
AIR 1997 Supreme Court, page 1007, if I am correctly remembering the judgment.
Well, it's what was raised but not answered. That is the other point that I wanted to make, which was why I made emphasis.
Who is the advocate and record?
He was there. He has been there through.
He has been?
He has been there throughout, right from the writ petition, which was allowed and then reversed in writ appeal. He arranged with you.
but the point which you are now raising, that was never argued.
My lord, this is pure question.
No.
Sir, lordships have recorded this.
Because
In the
I-
judgment.
So go for other forum. You can take that point. It's a pure question of law in that sense.
And Kamal,
But as a review is
well, the other point which was raised, let me argue on that, my lord. That is, my lords, that I lay emphasis on the purchase order. What were the terms of the terms of the contract? What was the work for?
We were on writ appeal.
Yes, ma'am.
Even before the
Writ petition.
in the
My lord, these dates
before
were
the
given.
learned single judge also
same page.
So, my lord,
was-
since
that was never agitated.
Judge,
in writ
Yes.
division bench. It was
I
not-
was one page here and there. It is 1006, not 7. So one page just. No, 2 page above. It should be 1005. 1005. May I read for you? The very first sentence is very communicative, I must say. It is a sad spectacle that a new practice unbecoming of worthy and conclusive conducive to the profession is cropping up. Mr. Such and such advocate and record has filed Vakalatnama nor was party in the main case. It is salutary to note that the court spends valuable time in deciding a case. Review petition is not and should not be an attempt for rehearing of the matter again on merits. Unfortunately, it has become in the same time a practice to file such without obtaining the consent of an earlier stage. It is not conducive to healthy practice of a bar which has a responsibility to maintain a salutary practice of profession. In the review petition, then the argument was quoted. Once the petition for review is dismissed, no application should be filed afresh, much less with the change of the advocate. It talks about advocate and record, but arguing counsel we can substitute with that.
And here also.
This practice of changing the advocates and filing the petitions should be declared, should be deprecated with heavy hand of that after a particular period, that is a date,
Yes.
whatever has been done that was found to be covered under this. I think paragraph.
And in that paragraph itself, my lord.
No, it's a small paragraph where
At
it's
page 28,
sorry.
para
Yes.
18, my lord, your lordship.
No, there is.
Yeah, my lord, paragraph 18, my lord.
No, 18 is no. There the paragraph begins with that we accept the contention of the counsel for the appellate or something, if I correctly read it. 22:1.
Uh,
22:1.
22. Yes, my lord. This was
In
their
our-
submission. This was their submission.
So the court has accepted
Yes,
and
my lord.
restricted
This-
this
this-
transaction
This is
subsequent to the filing of the memorandum dated 13th of December 2050 to be covered by the MES,
that is their
MSME.
submissions. That is their submission, not mine. He was the appellant.
Correct, sir. If
Now,
that-
my lord, the point is this, my lord. He concedes to the fact that only post registration the act would apply. I say one more factor was necessary is my acceptance of you as a MSME unit. Now, till I do that, my lords, the contract is itself vitiated because I do not know your status. The minimum thing which is essential in a contract is.
Sir,
identity
once
of
the court has
contracting party.
taken a decision that the provision of MSMED Act will apply post that particular 13th, 10,
Wait,
12, 2015,
yes.
then what remained?
Yes, my lord. My contention is it would still not apply.
That means that this particular judgment
Yes,
is erroneous.
yes, my lord. On this fact.
If it is erroneous, does it come under the purview of Order 47, Rule 1? There is a distinction between an erroneous order and an order suffers from an error apparent on the face of the record.
Error apparent
So
is this
there
one.
are two distinctive features. One has to make a distinction or a line of distinction.
No, well, that is where I'm saying the error on the face of the record is at page 34, if your lordship sees, of the judgment, where the court takes notice of the fact the date of supply by a registered MSME unit under the Act is the crucial factor for determination of the applicability. The date of supply. Now, date of supply from whom? That is the question that I asked myself, Malus.
So it's a erroneous finding, sir. By all means, it is an erroneous finding, which is amenable to be challenged by going higher up, but not certainly coming within the four corners of the review jurisdiction. Supreme Court has invariably held in many judgments that one should know the line of distinction between an erroneous order and an order which is apparently the order based upon an error apparent on the face of the record.
No, my lord, the error apparent on the face of this order, my lord, is a point which was argued, which was put forth. And
So
has
if it
not-
is wrongly decided, suppose if it is wrongly, let us go to extreme case. It is wrongly decided, then in that you could go before a higher forum. Because we are stuck with the judgment of the Supreme Court way back in 1960s, that's Tungabhadra, where the Supreme Court, I would say very lucidly, made a distinction and defined the jurisdiction of a review.
My lords, may I, in that case, may I pray that your lordship can grant me one more opportunity?
Definitely,
Let me
because I
come
put
back
you a
and try and
difficult.
satisfy your lordship.
However, I put you in a difficult situations, or put you a difficult one.
Let me come back and answer your
What to do?
Error of fact to see.
error of fact,
Error of fact.
apparent on the face of the record.
Error of fact apparent.
That let me do a little more work on this. Please, I'll come back. Your lordship can grant me a week.
Because my own judgment in another high court is staring at my face, where I have held so. So that is, no, I am still open, I tell you, my mind is still open. If I find there is,
Otherwise, I would not have ventured to come back.
if I find that my earlier view was not in accordance with law, I am ready to accept that and correct myself. There is no difficulty on my,
Your
I am
lordship
still
may
open because
grant me one opportunity a week's time. I will tell.
whatever you, what you say.
Now this form, the hospital already in the guise of what that could be an appeal situation. They are now coming.
No, I remember.
Oh, don't go by
I'm
what the
coming.
court orally observed.
I'm coming.
That is not always sacrosanct in that. It is only in pursuit of understanding the correct proposition of law, nothing more than that.
So the entire contention of there is that I have taken registration after having been awarded with the last contract. That's the case. Therefore, I'm not entitled to the MSME.
So according to them, they wanted to make a distinction that to avail that particular benefits under the MSME Act, the awarding of a contract is the paramount consideration, not the supply of the material. That is what really they wanted to highlight in this.
That's unfortunately.
This is the only thing.
That, not only that, I'll just add one more factor to that. This change in status, the change in status of the contracting
No,
party.
Mr.
has-
Mukherjee, we have gone to that definition of supplier.
Yes.
So
Yes.
going into that, we have interpreted
Yes,
that
Manoj,
this somebody
I am
has
also
supplied
I am
to
also,
this case when he has come forward to say that he has applied
has become a supplier
and subsequently
under
got
the
registered.
definition of the Act. But this change in his status of becoming a supplier under the Act has never been communicated to the contracting party. As a result, the other party remained in the dark, and there was no novation of the contract which the parties had earlier contracted. they are bound by the contract, that contract. Had the
No,
communication taken
that
place.
leads to the same basic point which I said.
Yes,
according-
I'll try and
Because
answer that.
you say that,
I-
that the change of a status does not invite a novation of a contract. That is what you wanted to say. It does not invite a novation of a contract automatically.
Automatically.
When you
That
apply,
sentence also from the other side is.
according to you, when you applied, your status was taken into account and the work contract was awarded to you. But if you have subsequently changed your character or a status, that does not mean that the contract is novated automatically.
Correct. That is the point.
Then just help on that assist here, my lord. This point is.
He is asking for a time to
That-
ponder upon the
this
issues,
point
then
is Now,
what
no more
more?
disintegrate. The Honorable Apex Court has decided that even if I do not have the registration, then also I can go for the entire period, for the period of which I am not insured. Here,
Those aspects we cannot go into
no,
here.
I'm just saying that.
We are in
this-
review.
What I'm
of-
saying, what my submission is that this law is no more disintegrate. So the Honorable Apex Court in a very recent judgment has said that registration or non-registration is nothing to do with my approaching the MSME, Facilitation Council. So that being the situation,
he
this,
says that there is no fetter in law that you cannot approach. What he says is you can definitely approach and then you can apply under the MSME. They can't put a fetter. But what they say is that if at the time of awarding a contract, there was no such status which you have disclosed or which has been granted to you, subsequent grant will not tantamount that you will be regarded as an MSME.
and that is
So this is what
the
he
Honorable Apex
wanted,
Court has answered. That's the
wanted
exact
to argue this
answer.
point. So this is what one has to understand.
This is the exact questions raised before the Honorable Apex Court and answered. That this is a welfare beneficial legislation and it cannot be restricted. The earlier law of the Delhi High Court has been affirmed in 2025 itself.
Perhaps we have
Yes,
relied
that-
much on Silpi.
And their total case was stand on Vaishno, which in that case, in the very recent judgment, has been said it's not correctly decided now.
Then it goes, if they are relying on Vaishno and Vaishno has been
I'm not
upheld.
relying on Vaishno.
No,
I'm not relying on Vaishno. Reference to the larger bench.
They have the repetition.
NBCC, which has been now referred to larger bench, I am also not relying on.
The first thing, my lord, they never, in the written petition, they have stated that this point only and only has been raised. That I have taken
So
registration.
true. One has to enter into two aspects in the review. One is the fact which was pleaded by parties, and second is on the basis of the fact what the law has been applied. If they wanted to bring a new fact, then whether the review is still the correct remedy, one has to understand that as well.
I'm on the very fact which has been they have stated, and the honorable single judge has allowed their case, saying that since I've taken registration after the award of contract, I am not entitled to. So on the basis of Honorable Apex Court's decision of Vaishno, that I contested here in appeal. And I have shown another Honorable Apex Court's judgment saying that this question is has to be decided by the tribunal. And that is what is the judgment recorded. Now, in the meantime, in 2025, it came.
Sir, you are not understanding what we say, sir. This is what is the change of law.
No change of law, my
No.
lord. That section 8
Oh.
of MSME.
Sir, change of law means the Vaishno has not been considered to be a good law. So this is what is a change, subsequent event to a judgment. And the judgment which relies upon a particular judgment which was operating in the field at the time when the judgment was delivered. Can we say that that judgment is bad because
No,
what was the law which was prevalent has been applied?
no, my lord. The Vaishno has not been held to be bad. It is stated.
Will not give scope for.
So, can't be.
Vaishno
He's
In law or
That's I'm not arguing.
subsequent judgments also cannot form part of any review, consideration for review. It is for the
I'm opposing review.
other,
I'm opposing review and showing that that's the position of law which
That is
which they
what,
want
so
to-
that is what the change of law we can't, we are simply on the basis of the facts and the law which was prevalent.
But this is not change of law, my lord. That's what I'm trying to.
Whatever.
you want to say that Honorable
Section
Supreme Court,
850.
Honorable Supreme Court subsequently whatever decides that goes to the inception.
No,
That is what
no, section, what is being decided here is a section 8, section 15, 16, 17 and 18. The reference is under 18.
So that means that we have to enter into the fresh argument and then hold that yes, his contention is wrong. Is it permissible in
But
the
that's
review,
what you-
revisitation of an order, rehearing of the matter and redecision to be taken?
Not.
Yes.
Your Lordship, can't be a week's time, then it is.
Whatever you take time to ponder upon the issues and
Since
prepare
your Lordship
yourself.
has said that your Lordship has delivered a judgment, let me read that judgment so that I can come back and let you on that. 17th, 16th, which was the day this can be. Subject to your Lordship board match.
I can give you a hint in that judgment because that was in relation to a DA matter of the Calcutta High Court. So where the review application was filed. So in that perspective, the review was decided by me.
I'll find it.
Sitting in a division bench. So you can go through that. I have hint that when reviewed lie, when it will not lie.
That will help me immensely. That will help in assisting your Lordship.
Find out. Adjournment on his prayer.
Order place reading.
Item number 4.
Now, 2 weeks to file counter.
Was that opportunity given to you earlier?
Earlier on 14, last time notice was issued, I was asked to file counter by 14/7, I have not filed. I take another 2 weeks time to file counter.
Is the first extension?
Yes, of course.
First extension. Normally we do like. How much?
2 weeks time.
Much.
Whom you are appealing?
Opposite parties, one and two.
The rejoinder, if any, and before everything a 1 week there are.
Yes.
And
3 weeks. Much. Item number 5.
Let's in this matter, I prayed for 3 days time to obtain instruction, but actually I have obtained some part instruction. I need to discuss with the officers, Miller. Because they have written something.
instructions one.
Yes, Miller, for the instruction.
very small one.
Yes, Miller.
We have not been able to gather. We have indicated in an earlier order only to the extent whether any decision is taken for extension of a period for execution of law. That's all.
Yes, Miller.
The only thing is yes or no. If it is yes, what decision show us? If it is no, no.
Yes. That's in my column, this matter there to come.
Why you are not doing it? Part instruction, what part?
Miller, actually, Miller, the instruction I have received, Miller, that is ambiguous. I need to talk with the officers, discuss with the officers. That's why only 1 day time.
In the next week.
Much.
Marks occasion manner directed to find the contributor with the Union of India, we have ready and we're filing today. We have taken a very simple plea, let's me remember. The state government filed a counter everything that they communicate 2009. But fact we are not finding that letter from ministry, but ministry agreed to execute the work if the state will upload this RAMAN portal. This now last few years the government of India has introduced a portal. Whatever things is there, it should be uploaded in the system. And automatically this ministry has considered this. That a period was filing. This merciless is the last page. Tell it copy of file.
Application for the scheme for seeking of permission.
Yes.
But have you got another permission?
Yes, my lord. If unless they are not uploaded in the portal, then ministry could not
matter.
that letter was page 24.
On the portal, the moment it is uploaded, they will.
The government would have considered this. Yes.
I just received the counter affidavit mailers. I'll take instructions. What is, if anything has
If you
been,
find that you have not yet uploaded,
then we will upload
upload
it.
it.
Upload it.
Then,
Yes, ma'am. Yes, ma'am.
That is instruction.
It is not uploaded. If they uploaded, then it's not.
Yes, ma'am.
That was given the letter also have given this. Page 24 R/4.
What issues they have flagged?
Then there is a slab. They are saying that because the flood is not controlled because of this. Yes.
Seven of
Height of,
That issue was there in Honorable Supreme Court, Your Lordship. I appear for the interveners. That was there in the Supreme Court. Initial height was 350.60 meters. It was raised by 3.5 meters, making it 364.10.
354.
Sorry, 354. So as it happened now, for compensatory measure, Honorable Supreme Court said you would comply all these. You can give extra land for afforestation, pay penalty and compensation. All these things the state government has complied, as I understand. And the Supreme Court has not specifically said that why did you raise the issue? Sorry, 354.50. You cannot maintain it at that level. My question is 25,000 people are dependent on this because 25,000 hectares of land, my lord, will be further irrigated if it is raised.
Porives portal is for all.
It will submerged into a water. If it is raised or what?
No, now they are maintaining at 350. Because if it is kept at 354, then the benefit will be about 10,000 people will be, village will be benefited because 25,000 hectares of land can be irrigated further. And Supreme Court has not said no, you cannot raise it. In fact, compensatory measures were suggested. Only they have to take a positive.
Only thing is this, the structural stability, the strength has to be taken into consideration.
That was considered. Engineers they have certified to that effect.
That it can be further raised.
yes.
It is already raised. Only they are not keeping the water.
The height of the dam.
They are not keeping up to that.
Yes, ma'am.
That level. They are maintaining at the previous level on the guise of Supreme Court's order. Supreme Court has not specifically said that.
The dam's full
That's why
reservoir
they
level.
step by day to reach a portal, it is called Porives portal. In that Porives portal, if anybody is agreed, they can upload all these things.
Let them upload, so we'll see.
Your Lordship. Yes.
I received. Your Lordship, actually, the authority for this is a tiger reserve forest. The authority of deciding whether afforestation activity are done or not only decided by the National Board of Wildlife. And in this order of the Supreme Court, the state government was approached the Honorable Supreme Court by filing a IE, and the Honorable Supreme Court referred to it to consider to the the National Board for Wildlife to consider it. The National Wildlife Board rejected it, and in this regard, I have annexed a parliamentary question and answer in Annexure 9, Lordship, and to kindly glance page 31. Where it clearly mentioned in the answer, there is no approval. However, the proposal for additional forest land of 142.699 hectares has not approved and violated the state government was intimated the proposal be treated, rejected and closed.
No, that was at that point of time. Subsequently, there was some.
Yes,
That order also speaks, my lord. That order of Honorable Supreme Court says, your lordship, we are told that the state of Orissa has already made available a total of 575 hectares of land
That is for
the forest department
early.
for afforestation, apart
the
from
project.
paying a compensation of 35 lakhs to the forest department for afforestation
Yes, yes.
purpose in lieu of the submerged land. So that provision the state government has made.
Now you see they are
It
demanding.
is also stated saplings have also been planted in this head land. It is also stated that decision to raise the height of the dam was taken by some officer, irrigation department. Height of the dam was taken by some irrigation department more than 20 years ago, and those officers have already retired from service. In view of the peculiar circumstances of the case and the compensatory action taken long delay, we are of the view that the proposed action against the officers of irrigation department should be dropped and the matter be closed. Because there was an attempt by some busybody my lord to prosecute them. So that being so, let them apply as AG my learned friend says, then we'll see, come back to your lordship and see what is happening. Why I am representing my lord, the farmers, this, they are, who is it? Pani Panchayat. And the president of that Panchayat is before your lordship as the petition.
Your lordship, the
So we are the
some
person-
alternative irrigation sources like deep irrigation or rainwater or harvesting. They are different, only depending upon the canal or this project is not necessary. My submission, I want to draw attention of this honorable court. Client glance to the annexure 12, page 33 also. What happened, Lord also? Due to increasing of the water level, the deep reserve forest of this is a tiger reserve forest. The Sunawada Wildlife Sanctuary was a home of 20 to 30 leopards and 4 Bengal tigers. And due to increase of height and of the water level, the core area of the tiger reserve forest is affected, and the tiger are come outside and attacking village people. These are some newspaper cuttings I have annexed. Annexure 12 is 34, 30. Sorry, sir. 43 or so.
Yes,
43, 44 and 45.
That is why Honorable Supreme Court says, however, MOEF may verify as to whether the afforestation activities are being carried out as stated, and if there is any lapses, further action may be taken in this regard. And the IS disposed of and closed.
When the Supreme Court passed the.
That was in 2008, your lordship.
It's a long time.
Incident of 2023 is reporting.
So,
That is the incident of 2023. Now,
I have demonstrated, my lord, 575 hectares has been provided. Afforestation is completing. That has been completed,
Now
my lord, in order to relocate this wildlife. That is the entire purpose. That's why MOEF is directed to verify. Ministry of Environment and Forest.
take care of that.
Yes,
because
May I submit further, your lordship?
Between the natural environment.
The appeal from the DO4 divisional forest may be required. Whether the application of the compensatory.
No, that will be MOEF. Ministry will give.
Fresh proposal has to be submitted.
Conflict between the human existence and the human existence.
Human existence, I remember.
No, that is taken care of, your lordship,
Well, it's here.
by the Honorable Supreme Court itself. But then what has happened subsequently, I don't know, that they will say. But I am
But the
informed.
Supreme Court has approved that particular raising of.
Yes, they have not disapproved. Now, question is, my lord, what I am praying
If
further.
it is approved by the Supreme Court, then in that event, if anything happens, then
It is pending before the Honorable Supreme
we
Court.
are bound by, we are bound by. We can't go beyond the judgment of the Supreme. By virtue of Article 140.
Until the approval, we cannot, they cannot rise in the level of water.
If the apex court has already granted them to raise the height and then also to raise the minimum level of water, then in that event, in the High Court pass an order contrary to that.
And it will benefit for all.
You have sought for certain orders which runs counter to or directly in conflict with the judgment of the Supreme Court or orders of the Supreme Court. Can the High Court pass such an order?
No, sir.
Then
The Supreme Court should not granted the increasing the height of
that
land.
is what they say, that it has been permitted.
I'm
It has been permitted.
not your worship.
This height increase happened 20 years ago, the Honorable Supreme Court said.
Court just dropped that proceeding, Your Lordship.
Yes,
No, no, ultimately the orders were passed to increase, if I correctly understood from their stat. Where is the judgment of the apex court?
This is in page, relevant page is page 22
Page 22.
of the Supreme Court judgment. The annexure is
High Court here.
annexure 4,
Annexure 4, Your Lordship.
page 21 onwards.
Clear to page.
That is what my learned friend is reading. It is paragraph 5,
Yes.
last paragraph.
Check 4.
That even the Supreme Court has tacitly, if they use the word, have approved that raising by 3.5 meters.
Yes,
They have already raised.
it was raised when they are
Already raised, it invites the deforestation or the submerging of the several forest land into it. And the state government has volunteered to provide a substantial amount. For that, they say for afforestation purposes, the sapling and all, everything is to be implanted so that at least the natural environment can be ensured.
So rising of height is different and storing of.
It says
of land.
and 33 point something lakhs of rupees to the forest department.
That is for the initial project, Your Lordship. Now actually the 142 hectares of deforestation affected. In this regard, the
No,
DOF also.
It is, what is there is, it says that deforestation and the area is also mentioned. 142.62 acres of land were destroyed.
Now
In
project
lieu thereof, they have already provided.
that
Uh,
that is for the earlier project, Your Lordship.
They have provided a substantial amount of
575 hectares.
575 hectares of land. And they have taken into account, that in 86, 339.253 hectares of forest land were submerged. And later on by increase, it is another 142.
Yes.
So they taken together, they have been provided more land, that is 575 hectares of land.
Exactly. Yes.
If you add 339 and 142, I think it will just reach 500, but they have provided more land. What more than the apex court has even dropped the proceeding against the hearing officers. And that means there is no order for demolition of that particular raising of the height from by 3.5 meter.
Your Lordship, the increasing of height of the dam is another factor. Storing of excess level of water.
Sir, that a dam is constructed for what purposes? For the storage of the natural resources of water, so that in a, I will say, in an adverse time, there will be a continuous supply of water for the purpose of irrigation. So that in order to avoid any drought situation to come. That is why the dam, otherwise there is no utility of the dam to be constructed. If the height of the dam is increased, taking into account that there will be a more accumulation of the water therein to be released in a time-bound manner when the situation so arises, then it's not a fanciful desire
of an authority to increase the height. What for? Just to accumulate or gather more water. Otherwise, height is not required. And while accumulating the water, there are certain forest land which get submerged. Supreme Court was of conscious decision, yes, it has submerged, but you cannot raise the height at the expense of the forest land, where the animals are at risk. To obviate this situation, the Supreme Court very categorically said that once the state has provided more land than what has submerged for the purpose of afforestation, then in that event there should be a afforestation exercise to be done so that the wildlife can be saved there. Here we go beyond that.
There is another aspect also, Lord.
Your Lordship, I want to draw the attention of this honorable court. Yes. Yes. Counter this one. Copy show some days later. More than the operation. Additional land.
My lord, there is another aspect to it. This district of Noapada is water star. My lord may not be knowing, but my lord, Mr. Murari must be knowing, my lord, Mr. Raman, that usually there used to be, my lord, famine. That area suffered a lot because of this drought area. And they depend basically agriculture. There is no industry in the entire district.
That is why the purpose of the dam to be created is for such purposes.
There is justification also. 25,000 hectares will come under the new irrigation.
The wildlife things also Supreme Court has taken care of. They are not
That is
excluded at the hill forest and the Madhya Pradesh also. The Central Board of Environment is also taking care of different.
If the forest will destroy, it will affect the climate and monsoon also, Your Lordship. The farmer will also may be affected.
What I'm praying,
If the forest will destroy, the core forest, it will affect the monsoon and climate also.
What?
Forestation,
Sir,
forestation also.
Afforestation drive has been suggested.
Suggested but
and
not
this
carry out.
will- So let them say afforestation has been done.
what I'm praying, let them upload in the portal. Then ministry should consult and take care of all the aspects because in portal there.
They saying that they have provided this land for the purpose of afforestation and 33 lakhs of rupees is also given. to-
Exactly, yes, that's the step.
Now,
Yes.
whether that land is actually given to the forest department.
Yes.
Money is also actually given to the forest department.
Yes, madam.
And whether the forest department has done this exercise of putting a saplings there.
Yes, that is also finding also, Lordship. Sapling has,
It says that providing a sapling and all, everything it is done. Whether it has been done actually or not,
that is why the MOEF has directed.
that is what is the main issue.
Your Lordship, the.
My lord, it is there. It is also stated saplings have also been planted in this area.
No,
Your Lordship, earlier provided the lands, the plantation site had affected. Client glance to the annex of the 13, Your Lordship. Page 46.
That's why the honorable.
The letter of DOCO, the Divisional Forest.
MOEF may verify as to whether afforestation activities are carried out
The
as
second
it was in
paragraph.
2008.
now you are talking about the increase the height, that height, this increase was done way back in 1990.
90.
When the order of the Supreme Court, 8, prior to 8. The order of the Supreme Court is of 2008.
Back to that it was, yes.
And it says 20 years have passed. So this increase was done much earlier.
Yes.
Then, now at this end, now they have to take care of that forest department. You are, Mr. Party, you are representing, you can represent forest department.
Comment of it, yes.
Environment,
Obviously.
environment and forestry.
That's why the department has launched a portal. That's why I'm requesting my friend, let them upload in the portal. I asked the chief, deputy chief conservator, they are saying that, sir, manual you cannot do anything. Let them upload the portal. The ministry as
Who will
well as
upload? The state.
state and the agri party also, they can upload the portal. Then whatever things will come up, there is a coordination between the central team, the state team, the scientific is there. They are examining the same and come to a conclusion.
This we can't, because these are the things we can't decide it, and these are the matter of India's concern. Now they say that they have already done. They say that I have also complied with.
Your Lordship,
Still
kindly glance
the
to the
conflict
annexure
goes
13, Your
on.
Lordship. My humble submission, kindly glance to the annexure 13, Your Lordship. Page 46.
Sir, what is this annexure? I have seen that annexure 13. What is this? You are raising a steel claim. You are really, this claim was 20-30 years before it has already been done. You are saying illegally they have increased the height. How can you? That by this time it is a 30-40 years period have already gone. Apex Court also took note of it. Apex Court has critical on that aspect. Yet the Apex Court did not take into account that you decrease it, demolish it. Did not. Had it been a case that the Apex Court has ordered the demolition there, did not. Even the steps against the hearing officials was also dropped, because by that time they are already retired. The only concern was that they have provided a more land than what gets submerged by virtue of increase of the height. The question now is that we can't go and say that it is illegal and everything. You can't. Only thing is whether the order of the Supreme Court has been duly implemented by the authorities. The afforestation, the providing of the land, everything has to be taken into account. So they say that if you have any objection or if you have anything to say, you can, there is a portal, you can upload it, they will definitely take into account everything. Unnecessarily you are raising an issue which is already foreclosed by the Apex Court in 2008.
My humble submission is
Simply because there was one incident that the leopard went.
there are several incidents. They are attacking also domestic animals. And the strength of a dam also in question. The affidavit
That raises several issues where there is a human habitations within that particular forest area since the time of
we need to make a balance
since the
between that.
time immemorial. That's what we study. Okay. There are many places where within the forest, since the advancement of the human race, somebody is already occupied. What to do?
One time.
In Balmala Dam project, I have never visited.
Palimar, yes.
Balmala Dam,
Right.
Indravati project. Ruduman, you visit those places, you can understand. How the aborigines live there in dikes and other.
I have a experience of another state, the Sundarban areas. There are human habitations, which is the main, I think, let's say the form of a one record type. And there is, sometimes the conflict comes.
Highly expressed.
Not reply state will find. They have come saying that there is a portal, if anything is done, you will definitely take it. Then what more? And the Supreme Court has already taken into account this. Your prayer I was looking at. Can it be now to maintain a permissible water level approved by the government of India to 350 points such and such? Then direct the opposing party number to initiate a proceeding as per the order against the officer of the irrigation department. Supreme Court has dropped it. Can be. Supreme Court has said, no, nothing is required. Can we go? Then,
But Supreme Court had strictly the.
no, Supreme Court observed that there should be an action taken against her. Last paragraph of the order you see, the Supreme Court says since all of them has retired, so there is no question, drop it,
Decision was taken 20 years ago.
drop it. And you are still claiming that they should be taken to task.
By the
How can
20
we-
years now, it is 17 years for them. So 37 years, around 40 years. As well as
Section 4.
Page 21, you start from page 21. Relevant page 20.
Look at it. It is also stated that the decision to raise the height of dam was taken by some officers of the irrigation department more than 20 years ago. And those officers have already retired from service. In view of the peculiar circumstances of the case and the compensatory action as long as the delay, we are of the view that the proposed action against the officers of the irrigation department should be dropped and the matter be closed. And you are seeking that the action should be taken against them. How can we go against them?
For the.
Please come. What is your second prayer? Your prayer is direct opposite party number 1 to initiate action as per the order of 19/2008 of the Honorable Supreme Court against the officers of the irrigation department who are involved in the afforestation activity. Means raising of the height.
Last two line of the order of Honorable Supreme Court. The Ministry of Forest and Environment verify as to whether afforestation activity being carried out as stated, and if there are any lapse further may.
Further means they say that they have already planted the saplings. If that has been done, then they are directed to carry out that. If the event is done, immediate steps
The
to be taken.
plantation
in
site
this
had
regard.
affected your lordship. The plantation.
Not to initiate a proceeding against the irrigation officers who have by this time, by God's grace, I do not know, many of them may not.
And saplings also, by now, we would have
We are,
raised to.
who is this gentleman?
Identify.
We are going to impose some cost on by taking out this kind of a frivolous thing. Earlier, the Supreme Court was very critical on that there should be an action against those erring officials. But later on, peculiar circumstances say drop, and you wanted the initiation. By picking and choosing one sentence from the others, and then wanted.
Lordship, give me another chance.
No.
Despite your
I
lordship.
think it's a time to come to bring up
Ambulance
closer. We have given you enough opportunity of doing that. It's not that we are not doing that. And after reading.
They have
the-
gone through this affidavit of the central government.
No, nothing. They have simply said any objection, if you want, you can upload it on the phone. Go there and upload.
Portal for the.
It is not for PIL. Definitely not for PIL. Not for PIL. Let us come back and we'll take it out.
I appear for the interview, my lord, my application has not been allowed. That is. Project
This
committee,
Lordship, I have another submission.
Pani Panchayat, upper.
Restrict your submission to the president. You have to in prayer. You cannot go beyond that.
Lordship, there is a report or inquiry report.
You are
Yes, yes, paragraph. And it's an R by 4, page 24.
whatever will go by this and will say that upload it on the portal, both the maintenance is directed. Let them go and. But If you invite us, then we'll make an observation on the basis of the Supreme Court. And the prayer which you have written. We have been really taking up this plea for one reason. That you have raised a serious concern. So far as the existence of the wildlife is concerned. Very serious. That is a very paramount. We are also very sensitive about it. But the manner in which you have started, this is not correct.
First, give me one answer.
Sorry, not.
Please, sir.
You are coming back and this is not.
Item 7.
That where is Mr. Harish?
Yes, and
One meeting, minutes of the meeting. Are you referring page 12?
yes, page 12,
To see
para 2B.
where is B? We do not find B.
Okay, it should be typically mistaken as a 2C, it's not 2C, it is 2B. The wrong. After page 2B.
So you have already rejected the diversion of those land which has been provided to the forest department.
Previous
for
account.
afforestation
Yes,
to be used for Upper Jong irrigation project in Moapara. That
Right.
means you do not want that irrigation project should be undertaken there. So this land remained the land for afforestation. What does it mean?
it is 25th August 2004, ma'am.
Yes,
Yes,
if you come to page 12,
yes, ma'am.
the item was diversion of 142.699 hectares of additional forest land for Upper Jog irrigation project. You have rejected.
That is additional. Initially, the land was allotted, the
For afforestation, because the Supreme Court judgment says that you have already allotted this land, the state government, for afforestation.
yes,
Correct?
If, page 22.
It says that in view of such increase in the height of a dam, additional area of 142 submerged underwater.
Yes, ma'am. IBWL rejected the proposal of the ground that it would be cause damage to the wildlife
Correct.
and directed action against the irrigation department of.
No, that is what is there. So it has submerged.
Yes,
So now, that is why since it has submerged, so you rejected the proposal.
yes, ma'am.
That is what one has to understood.
Yes, ma'am.
Yes, that's true.
Let's say when the state government file a counter, in that counter annexure E/6 page 23, after the order of the Honorable Supreme Court, the state government come to a conclusion. That let's say page 23 government of.
Where is the hard copy? Over here.
It's an affidavit, was there. Dated P7 2023.
They don't know what. It's not like.
Which one?
It is, let's say come to the page 23 of the state government counter. That is annexure E/6. Affidavit, not counter, affidavit. Filed by the state government.
Yes.
And that counter let's say come to the paragraph 8, page 7. May I read that? Serial number, paragraph 8, page number 7. Again, the Government of Odisha Forest and Environment Department requested the Ministry of Environment and Forest, Government of India to consider the diversion proposal of the forest land for increasing reservoir level.
So they have approached for reconsideration.
Yes.
Now,
That application didn't find.
has been done or not?
That the application not, it is not been done because the application not found present scenario. So that's why they suggested the state government to upload the portal. Then we can further consider for this.
But the consultation has already been done.
Initial-
It says it's not
Yes.
possible.
It is not possible.
Para 6 of that affidavit gives the entire history what has happened, my lords. Para 6, my lords. Para 6 and 7.
Elaborate everything, yes.
These are all there in the Honorable Supreme Court's order.
So these were the pre-Supreme Court order.
Yes, my lords.
So deliberation must be there in the before the Supreme Court.
Yes, my lords.
And the Supreme Court has said that a diversion when it is rejected, then in that event, what is the use of reconsideration?
My lords, because of the if I may refer to para 9 also, why during rainy season only the reservoir level is raised beyond 350.60, my lords. Not during entire year, my lords, because there are the situations are such that we have to keep the water above that level. Para 9, my lords.
No, you are storing the water beyond 350.60 metric,
Yes, ma'am.
whatever,
Yes, ma'am.
meters, during rainy season. So you are doing it.
Because situations
So
are
where is the difficult if you can do it?
Because the permissible limit as on date is 350.60. The full reservoir level is 3.354, my lord. This is the raised height, my lord. So during the rainy season only, because of the situations, we have to store the water beyond 350.60, my lords. Because the situations are such that or else nearby habitats.
You require that particular diversion
Yes, my lords.
which has submersed.
Yes, my lords. And afforestation has already been done and the land is already recorded in the forest department, my lords.
That is what they are saying FRL, flood reserve level.
Full
That
reserve.
height is, huh?
Full
Full
res-
reserve level
Full reserve level.
in meters.
So you make an application in
Yes,
the
ma'am.
OC.
Yes, my lord.
Just let them make an application.
With payment of the 38 lakh some odd is concerned. Only the state government taken a government that they have already paid in 1993.
Correct.
That means after Supreme Court order, they have paid.
Supreme Court has also recorded
Yes.
that the payment has been made.
Right.
33 point something.
35
lakhs.
Yes.
As compensation.
Yes, yes.
And land was also provided by them.
It is better, my lord, let them upload in this.
We are known to
But here I am challenging answer 6, wherein I have amount of rupees 30 lakh sought to be realized for me on the ground of illegal mining. Before your lordship, I take your lordship to annexure 6. May I take your lordship to annexure 3, your lordship? Annexure 2, I'm sorry, which is at page 67. My lord, by the order dated 10/7/2024, all the lessees were asked to stop mining because of onset of monsoon. 10/7/2024, page 67. My lord, again, wide.
You are been given a mining right.
I'm sorry, I am a lessee.
You were saying
My lord, I am a lessee.
by in that particular Boitarni river side land.
Yes, ma'am.
Bed.
Yes, ma'am. Now, my lord, we after the monsoon was over, at page 74, your lordship may see, I was specifically asked to resume mining along with other 3 lessees of other sand gravels. Your lordship may see page 74.
Yes.
Now, my lord, within that time, when I was specifically, all others were also specifically asked to stop mining activities. Now, my lord, your lordship may see annexure 3. That's the so cause notice. It is 27/9/2024. Your lordship, what? My lord may see the very first line with reference to the subject and letter cited above. I am to say that joint inquiry was conducted on 26/7/2024 by the competent authority with officials of Revenue, Odisha State Pollution Control Board and others, and following irregularities have been noticed. My lord, I stop here for a moment. My lord, take your lordship to the so cause reply. My lord, here a joint inquiry report has been said. No joint inquiry report has ever been enclosed. Your lordship may see a copy of joint inquiry report has never been served upon me. My reply is at annexure 4, where I say that when I have already you have suspended mining and there was monsoon, and a joint inquiry report has been conducted behind my back. I was never asked to remain present, nor it is your case that my men and machinery were found there when it was being.
What is your stand?
My lord, they are raising some disputed question of fact, whether the joint inquiry was conducted, notice was given to them or not. My lord, in the order impugned, my lord, itself at serial number 1, they have clarified, my lord, that why they were not invited to the joint inquiry participation. At page 76.
Where?
76, annexure 6 here.
Yes.
Let's say kindly have a glance to serial number 1, my lord.
Yes.
That was the reason for which the notice was not given to them to participate in the joint inquiry.
So according to you, your case is that despite the order of suspension of the operating permit, online, they were continuing to do mining.
Yes, my lord. And my lord,
I will, once my lord friend is done, I will take your lordship to, I will not shy away from anything, my lord. I will take your lordship. Why I am before your lord.
File your evidence.
yes, ma'am.
My lord, only thing is, your lordship may see, when the joint inquiry report has been served on me, which is at page 88, your lordship, you have taken action against me on the basis of a joint inquiry report.
Yes.
On my asking, you have submitted that report on January 27, 2025. It is at page 10. So, my lord, you seek to take a.
Sir, and let them file.
Yes, my lord, I am not coming into. Your lordship, I
Will find.
My lord,
Only to meet the submission of my learned friend, my lord. When they have replied on 10/10/24, in that if they have not received the joint inquiry report, my lord. Let's see the tenet of that.
We have written that.
72, my lord.
Oh,
Yes, my lord.
I have written that specifically, man. Lord, there is a judgment.
Item.
I'm sorry. But I am relying on a judgment of the.
I understand that the important piece of evidence, if it is not given.
My lord. That is
violation of principle of natural justice.
My lord, that's my entire case.
That's true.
My lord. It's my anxiety, my lord.
Yes, week, 1 week.
Right.
Wanted to appear on 24. Get it?
Eight.
8 October.
Item 9.
My lord, in the
You have
meantime.
been waiting for.
No, my lord, in the meantime, on 4/9/2025. No, my lord.
There was pause.
My lord, they were not taking any action because of the pendency of the petition. My lord, 4/9/20. My lord,
I anticipated that what you will argue.
No. My lord,
My lord,
I can only persuade your lordship. My lord, I cannot go beyond.
Why you waited?
I'll answer that.
When the order was passed.
My lord, the order was passed in
2024.
No, my lord, your lordship may see the last
23rd December.
No. My lord, your lordship may see.
What you were doing 23rd December, what you were doing from such and such people.
No, my lord, owing to the pendency, I wrote to them, they had not taken any action.
Find your rate, sir.
My lord,
In 2025 when?
February 1.
February 20.
Because 21/1/2020.
What you were doing from February to now we are in September.
My lord, I have given memos, my lord. I cannot.
Sir,
I cannot have.
If you can wait for 8 months, you can wait
My
for
lord,
3 weeks more.
No, my lord, what I was saying,
Yes.
if not realized, my lord.
Therefore, the order, you want a rejection order?
No, my lord.
Better.
Item 9.
This case will also just that state considered instruction regarding the action. As far as your also direct the state considered instruction, but action has been taken by the Tahsildar to evict the encroacher from the land of Lord Jagannath.
Oh, yes, that was.
Appeal was filed by the enforcement and that proceeding is still
Why
pending.
you are not taking a box to?
Next
Lord,
date is 16.
Land belongs to Lord Jagannath. How can somebody will take it?
Due to some
It is
ministerial
collective responsibility and duty of every citizen of the state to protect the interest of Lord Jagannath.
Well, it's the last two occasions because of ministerial strike. The next date is 16th of September, my lord.
The strikes are always declared to be illegal. By the apex court.
These,
Why
these two dates
to
were,
strike?
and second is training program, my lords.
What?
Training program of OSWA.
So you will spare the God for your training.
Once we have already informed them to complete the appeal as soon as possible, my lord. Letter has already been gone from our office, my lords.
It is submitted by the additional government advocate that we. Sorry. What? No, what she was submitting.
This case we are referring today.
I think the export has already foreclosed the issues
This matter.
in this regard.
Not only that, my lords, you must see the other prayers also.
I have seen the prayer, that's why I am asking whether that, I think it was made before the apex court. And the apex court has already, have you gone through that?
No, I have not gone.
Please
I'll check up. I'll check up.
Come in the next week.
Item 11.
I power.
Yes.
No, I think 11, I press the only time. Item 11.
Item 12.
Here the petition, the licensee of IMFL onshore since the year 1982, Lord. He was operating there on renewal basis and year-to-year basis up to Lord 2024-25. Thereafter, Lord, some part license was not renewed. So Lord, I approached this on court, and by that time they stated that the shop was functioning on a government land. So government land. It is on the municipality shop room, but they said it is the government land, so they didn't allow, and the shop was closed, license was not renewed.
Was there any amendment having brought in the meantime?
To that.
In this regard, that no license will be issued or renewed if the
Yes,
IMF.
Rule 23(7) says, if it is on government land, there will be no license. But it is 2017 law.
But it's still thereafter they renewed.
They renewed from 24-25 till. In the midst of the 24-25, they said that it may be inquired. Inquiry was made. The municipality said that it is my land. It is not stated that it is a government land. But however, I have approached this on court, and this on court has passed an order that you shift the shop. We will allow some time to continue in the existing place, but you apply for shifting. But I have applied for shifting. I have deposited 3 lakhs. They will not first process, but they will not renew the license from 1/4/2025 for the year 25-26.
This High Court has restricted the operation to.
No. Till shifting order is passed, I will be allowed to continue. That is the order. Your Lordship. At page 20, Annexure 5. Lordship, is the operative portion is para 3, page 21. Petitioner will apply for shifting with all particulars specified also. The authority will consider the application, and on petition fulfilling complying with the requisites.
This order, you have not challenged this one.
I will take instructions. They have collected 7 lakhs amount in the month of March for renewal of license.
But by virtue of this.
Yes, sir.
What is the grievance? You are protected by this order.
Yes. They should renew the license. Unless renewal, Lordship, unless renewal is made, the shifting process cannot be done.
Renewal is immaterial now. The tenant of the order.
Yes, sir.
Paragraph 3,
Yes. You are permitted to run on renewal of licenses there.
That his shop is on a government land, Your Lordship. So that is.
Madam. I think everything is foreclosed now. This issue was raised in the earlier writ petition. Court has accepted, court has said that we apply for shifting. The application till the decision is taken in the application is permitted to run. Yes. Can you raise this point? Tell us whether you have already decided the application for renewal or not. If you have not, he is already protected by an order.
Yes. No, the commissioner on 3rd/7, Annexure 12, sought clarification from the government on 3rd July. Now it is not September. 2 months have passed.
And you continued doing it when the municipality says it's my land. Not a government land. Yeah.
We can file an
I
affidavit.
do not know. What file it?
You should renew the license. They will get the license fee and they will get the duty also. They are losing revenue. They have already collected advance license fee from me. 7 lakhs they have collected. 3 lakhs for towards shifting. I have paid about 10 lakhs without my running the software. Though this Honorable Court has directed to allowed to run.
The money has been credited. They're saying that he has not submitted all other necessary documents for renewal of.
What the
All the
Main is that deposit.
deposit, it has been credited.
this is for shifting. It is not a renewal of the license that the existing. It says that so long the shifting is, decision is not taken, he is permitted to continue. So you will have to permit. Renewal is automatic. What more?
You will sit over there and wait for that.
You sat over it for a decade. He is entitled. Why is not running? I don't know.
But I claim before the authority that this is the order has been passed, you will have to give the effect of that order.
Oh, they will say that I have not prevented you.
No, they have closed from 1/4.
You have closed.
No, they have closed. I have not.
Order is passed for closure.
No order has been passed. Once the lordship license is not renewed, automatic it is. From 1/4 they have not
The
renewed.
order of page 3.
Allow you to lift any.
No, I was.
Page 21, have you seen? Paragraph 3.
It has been said that the licensee has failed to produce necessary documents like approved plan of the new site, registered lease deed.
That is for shifting, my lord.
For shifting.
They'll have to proceed unless they renew the license. How? I'll have to allow them to run the shop.
Then now.
Lord, I have given that.
The court will say that you will make an application for shifting after procedure, all the things have been followed.
Lord, I have given rent it.
No, he'll have to show is that you have not shown he's saying the plan or something.
Yes, Lord. Approved plan of the building.
Why you
Lord, that I will have to get from the landlord.
You'll have to.
Lord, I will produce that.
So why
I will
you
not.
produce-
Lord, unless
Produce,
I'll
they
produce.
will decide the matter within a time. Produce.
Yes. That is for,
First you go and-
Lord, with regard to process of shifting. But they have not violated the order. They'll have to allow the run the shop. Let.
Is difficult.
Yes.
If you make.
Look, I understand.
Please consider.
Yes.
If you make a defective application. And they say that I can't proceed because this is defective order. And you take advantage of this defective order and continue. You will never comply any requisition.
No,
Does it mean that?
Yes.
Does it mean? Will you not comply when they are
Yes,
given a
Lord. I'll have
requisition? Give a plan. Come with a clean hand.
Yes, Lord.
Saying that yes, I have complied everything. Why? How can they deny?
No, that I will come.
Do
That I
it,
will.
do it, otherwise you will not pass. Not passing. It talks about fulfilling and complying with
Yes,
requisites.
that is there. That is there. Lord, I agree, Lord. I know that is the order has been passed. That is. But my submission will receive unless the license is renewed or I will allowed to operate. I will give the documents. I cannot wriggle out from that.
Difficulty is. Should I be more open?
No.
Unscrupulous litigant, how we can misuse this order of paragraph 3, you do not know.
Yes,
Deposit when you will submit.
within not 10 days.
This is matter out of what?
Yes.
Item 13,
Let them also take instruction with regard to commissioners elected to the government. What has happened to that letter? And it's a 12 is the.
Case person who tendered dated 26 January 2024, the multi-level 7 number of commit was constituted for finalization of technical bill. Should I permit to place the 2-3 dates of my list of dates? 7 dates. Serial number 4 of my list of dates. The 7 December 2024, 7 number of technical committee constituted, I qualified. 10 January 2025, the government approves the technical bid result. Thereafter, 18 January, another 7 number of high technical committee constituted, evaluated. I selected in the lottery. Thereafter, the scrutiny was again, document was made 20 January 2025. In multi-level, they scrutiny all documents.
and 30th January 2025 recommended for formal approval. But now after 7 days, they direct for retender and 7 months, my lord. Now on 2nd August 2025, only one, they direct to council and retender, my lord, without any specific reason, my lord. Number 2, my lord, the uploaded portal is said administrative reason, my lord. At 7 number.
No Supreme Court judgment you will sign.
Yes, that.
I
did see that.
I will respond.
Yes, but I will also wanted to cite a judgment when the full court of this court has already decided.
But the apex court has decided.
Yes,
Well, it's in apex court, in that judgment, my lord, the work order were already issued.
No, there is one.
And school has been, that judgment, this judgment was not taken. It is prior to that, my lord.
Well, Justice Chandra's judgment, work order were already issued in the facts of that case.
Please file your response. Also,
2 weeks, 3 weeks, my lord. 3 weeks, my lord.
3 weeks, 1 week, 4 weeks.
In the meantime, my lord, they long.
Item-
You have decided to cancel, they are not voted.
Yes, the-
Item 14.
May I please, my lord? My lord, here in this public interest litigation, my lord, the petitioner is praying to quash the merger order of Bhadrak RMS with the Balasore RMS, my lord.
What is this RMS?
And Railway Mail Services, my lord. They are receiving speed post articles as well as they are sorting there. That is the main. My lord, my humble submission is, my lord, since last 6 decades, this Bhadrak RMS division is functioning in railway station, my lord. And after being heard, your lordship's dictum at serial number 2, my lord, I want to take your lordships to the impugned order, my lord, because there, my lord, pleases to hold power to shift should be given effect within the law, my lord. That's what I want to show your lordships. Now, my lord, I want to take your lordships to the impugned. Pardon, my lord. Yes, my lord. Running page 29, annexure 3, my lord. This is the impugned order. I'm reading it, my lord. This has been written by the CPMG Odisha Circle, addressed to the Superintendent of RMS Division, Cuttack. The subject is proposal of merger of Bhadrak RMS L2U with Baleswar RMS L2U, my lord. Here, my reference has been given that are interdepartmental communication, so I don't have the copies. I'm reading, my lord, the next paragraph. In response to your letter under reference, I am directed to intimate that in view of the upcoming MPOP project, it is upcoming, it is in draft stage, not yet finalized. There is no justification of ICH at Bhadrak RMS as per the proposed network planned by the director. Therefore, it is requested to kindly submit a conclusive proposal for merger of Bhadrak RMS.
That's what that be preparatory.
Yes, my lord. That's what I want to take your lordship to next page, annexure 4, running page 30, my lord.
Yes.
And my lord, to assist your lordships on that 3 strong grounds, I am filing this written notes of submission, my lord.
You are referring case 30 for what?
34, my lord, this is a draft proposal. This is a draft circular.
Whatever. Then what?
Then my lord, in this basing upon this draft circular, the annexure 3 has been issued. Annexure 3 is the impugned order for merger of the RMS.
It is not. They say that proposal kindly submit a conclusive proposal.
Yes, ma'am.
It is still at the consideration stage.
The next step is for merger. And
conclusive means the proposal for merger. Let them give a conclusive proposal for merger. If the proposal is made, then the decision would be taken.
Yes, my lord. In last, my lord, on 2/9, in a similar case, my lord, the Khordha RMS division has been merged with Bhubaneswar RMS division. That's why I want to assist, my lord. Kindly have a glance to my written notes, my lord. On this legal point, I want to argue, my lord. Effect of the draft circular under annexure 4, my lord. The MPOP circular.
Do you know the principles of law in this regard? There is a judgment. There are a judgment. Not is. There are a judgment. That if any action is taken on the basis of a draft rules.
My lord.
Which has not been approved
Or gazette notified.
Those actions cannot be said to be illegal or irregular. In the event such a draft rule is subsequently approved and will be notified.
That's what I want to show your lordship from these written notes of submission, my lord. Just I want to place 2 points only, my lord.
So you do not know what has happened. You can challenge the, because it is at the proposal stage.
Yes, my lord. The next step is merger, my lord.
No, proposal means they may not accept or they may accept.
Yes, that's what, my
If
lord.
they accept, then you can definitely come before the court.
My lord, one, my humble submission. One, my lord, that the petitioner could not supply me the entire annexure 4, my lord. That's why today I am filing the entire annexure 4. That is vital, my lord. 2 copies. That's what I want to show, my lord. That annexure 4 is that the draft circular, my lord.
True.
Yes, my lord. That's from that I want to show your lordships, my lord.
Let
That
them
is-
file all the documents with the affidavit.
No, my lord.
Piece of paper.
No, no. One humble submission, my lord. There, my lord, kindly have a glass to mark it as pink, my lord. Which they want to merge. As per this draft notification, they want to Paleswar ICH, Jajpur, Dhenkanal, they propose to be closed.
Proceed, so if it comes on the basis thereof, they make a decision, then definitely we will consider whether they can do it or they cannot do it. But it's at the proposal stage, is it not a premature? Because this letter simply you are asking for, they wanted to submit a conclusive proposal for merger.
That's why my humble submission is, my lord. I want to show only last paragraph. I want to submit my written notes of submission. Next page, my lord. Second page. That is, my lord, violation of consultation requirement. In my minutes of meeting dated 23/2007, I have annexed it at Annex 6, my lord. There, my lord, the minutes of the meeting held on 23/2007 between the Department of Posts and recognized unions clearly records that it was also agreed that circles should consult the service unions at the circle level while taking a decision with respect of merger, closure, and mail offices, my lord. They have not done it.
If they do not do it, accept the proposal, we can definitely come and raise those issues.
After merger, my lord, immediately, my lord, one submission, my lord. After merger, they immediately hand over the place to the railways, my lord.
What? This is what is the railway is already there. The railway is already there.
It is in the railway premises, it is running, my lord. Railway premises, it is running the RMS centers. So, my lord, my humble submission is that that without consultation with the stakeholders,
What is the distance between a Bhadrak and
it is 65 kilometers, my lord. What will happen, my lord, now, my lord? There are 55 substations of post offices.
Is it not a transferable job?
Pardon me?
You are in a, I think you are in a.
No. Here the veteran postal who retired from service, he is challenging, my lord. What will happen, my lord?
I have asked. Is it not a transferable job?
The employees, my lord.
Post office.
Yes.
So if one can be transferred from Bhadrak to Balasore.
My lord, I am not there. What they are saying
Yes.
no, my lord. What my humble submission is, they are merging it with the Balasore RMS, which is 65 kilometers away.
You would not understand what is passing in my mind. Please try.
No, my lord, I could follow, my lord. When my lord pleases to ask me.
Where is the problem? If it is a transferable job, suppose if there is no merger, can they not put you from Bhadrak to Balasore?
Yes, my lord, but due process of law. That's why my
It's a due process of law.
No, my lord, that's why I am submitting.
Transfer is within the wisdom of the employer.
Employer. That I have no dispute, my lord. My lord, what is my humble submission, my lord?
The merger, I understand. Your problem is that the merger will uproot all the persons from Bhadrak and they have to.
The balancer. They may join or not join. I am not concerned there, my lord. My humble submission is, my lord, basing upon a draft policy. And what is the language, my lord?
Yeah, but it is still at the proposal stage.
Yes, and the Bhadrak RMS is not in the list which I have supplied to my lord. Other districts are there, other, my lord. They are targeting this Bhadrak RMS division, my lord. Let them at least take instruction. My representation is pending with them. Union representation is also pending with them. They are not considering the same. Let them take instruction, my lord. My humble submission. And what, my lord, it will definitely one humble submission, it is cost effective. That the postal department competing with the Mintra and yes, my lord, policy. This is draft, my lord. This had not seen the light of the day, my lord, my humble submission, my lord. Let them take instruction at least.
Yes, Mr.
And these postal staffs, sometimes they will be in head post office or any post office, again they are to RMS. There is no separate cadre.
But we are for extinguishing one post office.
No, man. I'm just
For all time to
I
come.
didn't have instruction, but what I'm dealing because this I'm dealing just time. In RMS, only dispatching of letter is only one. There is no other one.
Speed post.
Speed
Registration are there.
Now
Parcel
registration
are there.
stop.
Registry letter stops. Speed post doesn't stop, my lord.
But the registered post has been stopped. Now the postal department in future only speed post.
Why? Mr. Post.
Now they have stopped.
Since last 2 months it has been stopped.
Why?
Because the speed post, previously there is no scope to deliver everything on speed post.
To generate more money and adding GST. Sorry, man. Sorry.
So
The difficulty is, are you accepting the acknowledgement due card in the speed post? as well?
yes,
Are you?
yes.
And my lord, here, my
There, even though there is no AD,
Acknowledgement due card.
yes, we can give.
The reason is there are many, I would say the evidentiary value you do not know.
Exactly, man. That's that part of it.
If the acknowledgement due card is returned containing the
Sufficient of
signature,
notice,
then
all
this
these
is a
things, yes.
strong presumption, and your only thing is that it is item delivered. Who received it? Who has not?
that has not been verified.
Nothing can be proved from there.
Man, what happened now? The person who
This is must. General post office is available.
Yes, that's what I am submitting. But they are sorting here. If one example I want to assist man.
They are accepting this.
Yes.
Speed post.
55
They are only to give
sorting it.
Sorted. So in what way you are prejudiced?
This is for public interest. I am not personally affected. Otherwise with
The sorting is done in Gujarat or Baleswar or in Qatar.
That's
in
what
way you are prejudiced?
my lord, it is my lord, not personal interest, my lord, it is public interest. What I want to assist, my lord, I want to assist lordship's query, my lord. What will happen, my lord? It will be delayed. Again, extra cost. How I want to assist, my lord? There are 55 subdivisions are there. They are receiving the speed post article. Then what it will be done? It will be go to Balaswar, 65 kilometers away through road transport. Then immediately it will delay.
completely wrong concept.
It will delay.
Completely wrong
It will
concept.
delay the. Let them answer on that point, my lord.
I
It will be delayed, my lord. My humble submission. Kindly visualize, my lord. 65 kilometers they have to adopt. The transport by road they will go. It will go it, my lord. So definitely the purpose of this proposal as well as circular may not sort out. Rather they are going to compete with the e-commerce platforms, my lord.
So what they will do it is up to them. How they will take those staffs where they will utilize their services is their baby.
Because, my lord, the draft policy aim will be frustrated, my lord. My humble submission is this draft policy or
The draft policy, we will not say that's the draft policy. Suppose if there is no policy. If they have decided The proposal comes, can they not?
That's what I am submitting. I want to show from that draft
Why
policy,
you
my
are
lord.
backing about-
That the Bhadrak was never referred.
Have you seen, there is a party to that page? When schools are merged. We have confirmed.
That school,
School man.
government
Before
school.
the policy, can they not? It's a different school.
So in the
Take
similar.
This is one.
Take an instruction, Mr. Pard.
Pardon me, pardon.
But there is a annexure 7 for a one of
Two
C.
days.
Yes. Instruction, but page 13 is clear. All the stakeholders have been taken into consideration. They have discussed and decided.
He's saying that it is still at the draft level stage.
Modern, modern.
Then you make it a final document.
Yes, ma'am.
My lord, one humble submission, my lord, one IA is there, my lord. Subject to result, at least, my lord, subject to result.
No, we can't.
Item 50.
As the show cause notice, not even the hearing notice, even though there is a reference in the portal, but none of these documents have been uploaded in the portal. During the last occasion, Lordship has seen that at page 33 of the petition, Lordship.
Sir, the documents have not been uploaded which you want to rely upon.
From our back office, from our portal, your lordship, it is ascertained that those attachments are there and those attachments have been uploaded. Your lordship, the second page, the final column, your lordship,
We can't read it.
your lordship.
We need a magnifying glass to read.
Your lordship, the attachments, the right side
So
column.
busy that.
We
The
can't.
attachments are there.
Can anybody read it?
Your lordship, for that reason, I have opened my mobile phone.
Open your mobile phone.
Soft copy, your lordship.
Can't. The font size is, I think, that is also not, computer has also not accepted it.
Mr. Janapur.
Your lordship.
Lordship, even the last occasion, Lordship, even we checked on the website, even at the time of the hearing thereafter, even thereafter
Your
also.
lordship, I leave
But
it to
it
your lordship.
may be, it shows that from your end it is there, but from the perspective of
Your
the
lordship,
SSCs,
that reason.
if that is not open, then what can be done?
For that reason, I leave it to your lordship, two option, your lordship, my humble submission. It is shown in my portal and everything has been uploaded. And petitioner's allegations,
That's what I was saying.
your lordship,
That
only,
sometimes it shows that it is uploaded, but the document itself is not there.
your lordship, what happened? If those he could not seen, it could not be seen to him, then he could have raised a ticket to the GSTN. Whatever he has not done, this is admittedly ex parte order. So it is shown in my portal, it is not shown in his portal. So what my humble submission, your lordship may allow me 4 weeks time, I have to raise a ticket before GSTN and GSTN will confirm. Only GSTN can confirm that whether he is right or wrong.
So, Lordship, they are raising demand.
Read the password, ID and
Lordship.
password to his local
Lordship,
council.
they are raising
Let him
demand.
fit with
The
me.
person, Lordship, who is
Because I cannot
demanding,
move to his portal.
and as per section 73, they need to serve the order. They need to serve the show cause notice. There's not even a
Everything has
service
been
of that.
solved. I'm disputing everything has been offloaded, everything has been
Sir,
solved.
rather,
169.
this bench has already taken a view that there are several modes of service.
169.
And there is, that includes the uploading on the particular official website. And therefore, we are not taking up that conservative view of sending a letter through post or sending a letter through any other mode. If it is uploaded and available to be viewed by the SSC, that itself is a service. There cannot be any dispute in this.
If it's
But the only thing is, you say that any document which is appended to a show cause notice having not served upon you means you cannot open that particular PDF file or attachment. That's, we concerned, yeah, we find it's a good ground because everybody is entitled to the same. You can't proceed on that.
Your Lordship, give the ID password to the local council, let the local council.
Now, if you have rectified your system, then now, then what
That cannot be
done?
cannot be rectified at any time.
You have
Whatever there.
the computer software engineers, you have the dedicated.
That cannot be.
Mr. Markets, has your client approached the authority by saying that I have not, this document was not uploaded? Any document can be shown from your end that you have brought this fact to the notice of the authority concerned?
We have done, but we haven't annexed any such document. I need to take instruction.
What? No, your senior, what is saying? Your senior is appearing.
Your Lordship.
Yes. What my lord has asked a query.
Let me.
Yes,
I'm sorry.
I think the senior has not.
Your Lordship, I have missed something, Lordship.
That way.
Okay.
That's why I'm asking him.
Lordship, Mr. Sachdev will appear.
Yes. No. You must have briefed him that this aspect, whether your client has gone to the authority by putting a word to him or approached him saying that I have not received, even though the portal shows that document is attached, but it is, I am unable to download or it is not there.
Have you raised that concern?
Lordship, let me take instruction.
No, Lordship, we got to know when this order has come, because this was the only document which was uploaded. And rest of the document there is only reference, but then nothing was there. And as Lordship under section 73 or 74, the onus is on them to at least serve me the notice. And it's not, it has come through email or post, etc.
Let me clarify the system of uploading, Your Lordship. The system of uploading is that once a document has been uploaded in the portal, a pop-up has been done, a pop-up will go to the mobile, registered mobile, and another pop-up will go to the registered mail ID. So immediately he can look into, open the portal by knowing that.
For that it has to be uploaded. If it is not uploaded, then how it will be?
The pop-up means that it will come in the system when they are already online and the computer. But these are the messages which goes either through mail or through SMS or whatever the reason. These are the communications. Their stand is they never received those. They were not.
Have
you pleaded that you never received any communication? You never only accept the order?
Yes, Lordship. We have specifically mentioned it in our petition, Lordship.
Where is that?
Kindly see page 5, para 11, Lordship. That the petitioner respectfully submit that neither the intimation notice in GST ASMT 10.
I'm sorry to disturb. He has filed a reply pursuant to this ASMT 10.
No, ASMT 10, nor the Shoko notice in GSTR 01A were uploaded on the GST portal or served upon a petitioner by any means of communication, including electronic email. And hearing notice have also not come, Lordship. So neither the Shoko notice nor the hearing notice.
Mr. Sachdeva.
Yes, Lordship.
Standing counsel says that pursuant to this ASMT 10.
Yes, Lordship.
You have given a reply.
Which you claim you have not received. But you have.
Lordship, we have not filed.
Your client has given a reply to, responded to this.
Lordship,
given a reply.
Lordship, as per my instruction, we have not filed any reply of ASMT 10.
Your Lordship, first page. The said discrepancy apparently found out by scrutiny of return was communicated to the taxpayer at ASMT 10 by reference number so and so.
Lordship, as per my instruction.
Inviting the reply, the taxpayer has submitted his reply in ASMT 11.
Oh, then this is a. Because you have said that you submitted the reply on 1/6/2022.
No, Lordship, I need to, as per my instruction, this reply was, we have not filed any reply because this ASMT 10 has not been served to us. In fact, if you Lordship see page 21 of the impugned order, they have been referring that these everything has been served, etc., etc. Those things are falling flat because none of these things have served. Now I do not know from which basis my learner friend is now saying that we have filed the reply of ASMT 10.
Your Lordship may kindly look.
So just wait. Yes, Mr. Sachdeva.
Yes, Lordship. Now, if Lordship can see page 21 of the impugned order.
No, I'm looking at page 21.
Yes, Lordship.
But the difficulty is that once you have given reply and thereafter you did not participate, then the presumption is against you.
No, Lordship, we have not filed any reply. That is the instruction that I have received from the
Then
client.
where is the
We have
reply?
not filed any reply.
From backside, the last third page.
This is the ASMT 11.
Your Lordship, the manager authorized signatory Soumya M has filed.
Some Soumya M has filed, the senior manager.
I have, Lordship, I can
You
just
take instruction from your client.
Pardon?
Have you got this
Copy of the case.
instruction?
Are you looking at this page?
Please.
Page 21. No, not this. I haven't.
You come to page.
Last but three sheets. 1/6/2022.
No, Lordship.
1/6/2022. Right?
Yes, my lord.
That is ASMT 11.
Yes, my lord.
So this is after ASMT 10.
Yes, ma'am.
Your plea at page 5, paragraph 11 is that you have not received ASMT 10.
Yes, ma'am.
But how could you
Give a
file
reply.
this, reply?
Lordship, can I take an instruction because I haven't.
Definitely.
You take, because this is something which has come that shows that you were intimated.
Yes, ma'am.
No, but Lordship,
You see column number 5 of that
yes,
page.
yes, Lordship, yes, Lordship. But the fact of the matter, I need to take instruction about ASMT 10. I was not aware that ASMT 10 has been received or any reply has been filed. That's the instruction which I received from the client. But the fact of the matter is my learner friend is not able to demonstrate because this is the order against the SHOKO notice. Neither the SHOKO notice has been issued nor the reply has been filed. Lordship can send me the matter back to the authorities. Let them issue me the SHOKO notice. Let me file my reply. But at least I should be given an opportunity.
1/9, which is ununderstandable. That's why the authority says that it is not satisfactory. You are not approaching the authority.
No.
Reply to GST ASMT for difference in GSTR 2B and GSTR 3B for the period so and so for notice reference. It is unintelligible to comprehend anything from this serial number 5 of ASMT 11.
Yes, ma'am.
So you have given this reply this much only.
But Lordship,
It is
now the whole
incomprehensible.
demand, the Lordship, the whole demand is against the SHOKO notice. My humble,
Let him file appeal, your Lordship. It is appealable order. Let him file appeal.
No, but-
Extended forum of assessment.
no, Lordship, let it go back to the authority.
Let us see when he is saying the principle of natural justice is the paramount primary. Let us see if we do not find that there is any infraction of the or violation of the principle of natural justice, then we will relegate him. We will refuse to. This is our discretion. If there is an alternative remedy, is our discretion. There is no absolute bar. But we can relegate him. So you have shown. Let them take an instruction. If it appears that ASMT 11 has been given, that shows that there stand that the ASMT 10 was never served upon them, nor anything. We'll see to it. What is that dictum? There's a legal maxim is uni falsa or what? What is this? That will apply.
Mr.
Is come.
perhaps we are comprehending wrongly as per your submission. You come to para 2.3 of the assessment order, which you have enclosed here. Para 2.3. Perhaps I am failing to understand. Para 2.3, please read aloud.
The instant taxpayer has been.
Hmm.
The instant taxpayer has
Oh,
ultimately.
then again that, yes. Thanks to my brother. Thanks to my brother. Read 2.3.
The instant taxpayer has been intimated regarding excess claim of input tax credit in ASMET 10 by reference number so and so, dated 27 2000, wherein the taxpayer was directed to reply in this connection. The taxpayer.
Read.
Yes.
Neither replied nor.
How can you say reply is given ASMT 11 and here you say neither replied, then
Your Lordship, reply has been filed. but
whatever your instruction is something.
My lord.
Mr. If you file affidavit, we will take cognizance of this. You file affidavit.
Your
But
Lordship,
you file that he has
we are fine if this matter can be relegated.
it to the authority.
If this matter
and
can be
he
remanded back.
reply. You file that document, please.
only one line reply has been
Let us see.
filed for that.
Let us see.
reason.
Let us
That
see.
is not.
File affidavit. File affidavit.
We are staying
On
the
that.
debate.
Yeah.
You are wrong.
Inconsistency, we can see. If there is an inconsistency, then what to do? Should we rely?
Your Lordship, with great respect, this cannot be generated. This has been filed. Admittedly, this has been filed.
Sir, assessment order speaks this.
Your Lordship. So since that is no supporting document has been filed.
Can you, the assessment order proceeds, that means another question. That shows that the authority have ignored the reply which they have filed and there is no consideration of the grounds taken in the reply. If that being the position, can the order stand?
No ground has been.
It's a whatever is a non-application of mine, then order has to go straight away.
I leave it to Your Lordship.
Then order has to go straight away. Whether they have taken a ground or not taken a ground, it has to go in that way. Take instruction whether you have filed it or not on the next day. We are keeping it on Monday. Take instruction, come back.
We'll take. Obliged, Lordship.
Item 22.
And keep the instruction filed by Mr. Mishra on record.
That the last. Your Lordship, at the beginning I have submitted. My humble submission, I leave it to Your Lordship.
That is why
Lordship,
keep it on record for this.
Lordship, we are fine if this matter can be
It
relegated back.
seems that is mechanically.
Yes, next.
Item 22.
My pleasure, Lordship. When the council has taken instruction to accommodation regarding the action of the EAC. But in the meantime, petitioner is a small businessman supplying the manpower, the equipment, etc. to the applicant. Part number 2 is the RBNet. What is the payment was hold of around huge amount of payment was hold. So already petitioner given the representation of 7th June and 19th June to the opposite party, but he was not released his payment. Another.
Why you are not releasing the payment?
GST only.
Who is for the GST?
I didn't have received any this amended copy. Only my lord.
Amended copy you have not received. Have you not served?
I have not been served. Only for 1 and 2, but I don't have a rule. The GST will take care of it.
I have just now getting instruction from.
He says he has no role. You are saying you have no role.
Right, no rule. We don't have that power to change the
But
things.
he is not made party. You are not made party here.
I not directed to implement the GST as a party. They have amended. Now they have considered petition. You don't have, but he is a copy. He is saying.
Consolidated first statement that big jagger again.
The instruction is such, they are saying that the authority has no power to refund. This very poor
Then who has the power to refund?
Necessary correction will be done as per GST. So direction, board may decide the direction.
What?
Let them file this, they should file the affidavit. File it. Let them file it.
File affidavit. 2 weeks. Let them talk. Then we'll see. Yes.
Item 23.
Right. I know this is regarding this missing of dots between rupees and paisa. Your lordship in the last occasion was instructed and within a direction for re-verification of an USOP account along with my return to that it's factually correct. We have submitted our all the documents and USOP account with the invoices directed by your lordship. I order dated 8 August 2025. Order number one.
What has happened, Mr. Mishra? Mistake.
Only dot. 1 lakh to 1 crore euros.
Your lordship says that this is already, assessment has already been completed. And the 161 has been rejected, your lordship. Your lordship may
So you wanted us to exercise the.
set aside that 161 order.
Right.
Not assessment order is not required to be set aside. Your lordship may set aside the 161 order and rectify and necessary direction may be made for because so moto because time has been and let it not be a precedent. Your lordship, because the rejection of 161 is due to time back. Your lordship may kindly turn to page 18. 1A.
Yes, it's one ministerial error.
Necessary rectification in this figure.
Yes. When a substantial justice is pitted against the technical justice, then substantial justice must prevail. And this is too technical because a person has, this is a human error. He could not put dot between two figures.
Only not only human error. For a moment, if your lordship will imagine, he has done the human error. And again, he has claimed. The entire amount has claimed. Subsequently, when it came to notice, subsequently in 2023, he has reversed. Not only that, this is a human error, only technical error. So whatever, I don't want to go into all the details. Your lordship only.
Yes, yes. That's it. Yes. 160, only on that ground of the reason.
In this context, the invoices submitted. They are 2A in the GST portal. And what about 3B? Why didn't you check up? Why didn't you do that exercise? You could have very well found out the error.
Your lordship, once it is appearing in 2B.
And suppliers, in other cases, you are disallowing the ITC.
नहीं 2A रुपए देखिए cross verify 2A होती तार BB आओ but below.
Then what have you found?
No. What happened? 3B रे in 3B.
The selling the supplier also would have uploaded his invoice. You have
verified.
Have you matched? Then what have you found?
After matching, we have found that
the dot is the problem. Yes. So,
because 2A, 3B is his return, 2A is supplier's return. So supplier's return and dealer's return, 2A, 3B, match, after matching that, we have given this.
Then at the time of 161, you didn't do that.
161 time bearing reject. That has been rejected on time bearing. 3 months, 6 months.
Anyhow, yes. Call the next.
Item 24.
Please, my lord. This was issued the wrong email address. So the petitioner could not participate in assessment proceeding. The expert.
Wrong email address.
Yes, ma'am. The email address mentioned in the page 18 of the assessment order. And it's true. Page 18 is the notices, the date of serial number notices. That
Yes. Where?
Rajendra Danda Patha, actually.
Which one? Rajendra?
Rajendra Danda, DAMPAT, actually DANPAT.
N.
N.
Not a M.
M.
So it must have bounced back.
No, it's like deliver on email ID it has been written.
Huh?
In remarks it has been written deliver on email ID in this thing.
No, cannot be because it has to return. Rajendra Dandapat. Actually, Dandapat, it should be you have given a Damdapat. According to him, is a Dandapat.
Yes, it is registered in the income tax web portal.
So,
Even if that email
if somebody has the email,
this has been uploaded in the portal.
whatever, if he has if somebody has the email of this, might have gone there.
Apart from we have sent to speed post also.
Where is the show, the service of speed post?
Column 9,
Where?
page number 19.
Yes.
Sent by speed post, show post note, issued central communication.
Where is the track report?
And the track report I have enclosed in 34 pages, there is no such service. Annex of one.
Yes, 34.
Yes, ma'am.
Oh, you have taken.
So I got notes. After the assessment. order-
Consignment details not found.
Yes.
After 3 months in postal, you won't find anything. It's an applicable order there also.
Not produce any evidence or anything. Before asking first appellate authority, it will be additional evidence under rule 46. Will be treated as.
So this is a consideration. Now 148 notice has been issued.
No, not solving. That is also the wrong email address. That serial number
148 notice also.
Yes, ma'am.
We have followed all the procedure of the lordship. 148A notice was issued, and then after no reply, 148A order was passed, and after passing that order, 148 notice was issued, and simultaneously lordship notice under section 142(1), 133(6). Also,
Now, what is the period of limitation for filing an appeal against this order of 148?
30 days. 30 days of passing of the order.
And what is the time limit within which the condonation can be done?
There is no outer limit in income tax. There is no outer
There is
limit
no
in
outer
income.
limit, I believe.
May be condoned by that. It may be condoned by that chief of.
So if there is no outer limit, then go for a, you take that plea, they will produce the evidence.
First appellate authority has no power to set aside the assessment.
What?
First appellate authority has no power to set aside the assessment.
Then what for they are the first appellate authority. I am asking you then what for the appellate authority is there. If we cannot set aside the order, then it is a farcical approach to create a first appellate authority. If we cannot reverse the order, cannot set aside the order, it is only for giving a rubber seal of affirmation.
One more
It's settled like this fiscal statutes. Statute, they have restrained him from setting aside and remanding.
Remanding, they have no power.
So the first appellate authority has to
Decide the matter.
decide the matter on merits.
So what they will decide? If they found while deciding the matter that the order of the assessing officer is not sustainable, can they not quash it? So
that will be beneficial to you. By then,
you go there.
But I could not get a chance before the assessing authority. That is.
No, you will get a chance. Go there. There is no outer limit. Condonation will be done. Site that you have approached the. Go there. Yes.
My prayer is in all legal to issue also before the First Appellate Authority.
You can't. You can take. You can take. Go there. Go there. No, you will let him go to the first appellate. First. Yes, call the next.
Item 25.
25 will also be last cancellation.
Yes.
Yeah. Item 26.
These orders are very good. That's something. These orders are very good.
Registration certificate. 26.
Both the cases.
Next.
Item 27. Item 28.
This matter relates to section 73 Postgrad Finance.
pending before the Honorable Supreme Court.
Yes,
Restraining High Courts
yes,
not to proceed with.
Yeah.
Yes.
73.
Item 29.
File ready, the author. Has directed the correction of the date of birth and also correction of the names of the hospital. Although there is clear prohibition, Honorable Judge says that this is
The
an
correction where?
exception.
Your daughter is still studying in a school.
I am responsible. I am from the secondary education, board of secondary education.
No, correction of the date of birth and the name in what?
In the school records,
In the school record, not your record.
not by me. I am.
Has she appeared in class 10 examination board?
No, not by me.
She is in class.
Class 10, he is in class 10, not every.
So before class 10, the board.
Over, yes. Class 10 is already over in this session. But certificate is not yet given. There are also proceedings then. Okay, you will also see at page 70. Petitioner's daughter has not yet appeared in petition for board exams.
Yes.
Page 17, paragraph 7.1.
Yes.
Last line. Similarly, in the case in hand, petitioner's daughter has not yet appeared the 10th board exam. So before appearing in the examination, the question of correction of the date of birth in the certificate would arise after she completes the matriculation. 10th class.
No, before that, why not?
Before that, it's before the school. The DE
Correct.
was rejected. The district education officer on their application has rejected it
So this rejection order is under challenge.
of the DEO.
Correct. So that order has been set aside.
Yes,
Once the order is set aside, means the correction is automatic. That has to be done.
This was rejected on the ground that it's an exceptional circumstance. There is no, you're also kind of.
If there is no reason, then why not? And I do not find, suppose, what is there? If they say there are other supporting government document,
That's subsequent.
which shows,
At the time of entry, whatever document is produced, that was recorded. If there is a clerical error,
it can definitely be corrected. But so far names are concerned, parents' names, they say that inadvertently we have given the names of the aunt and uncle. There will be declaration saying that who has given it and as guardian and.
So have they produced any certificate from the hospital that where the name of the
No.
Yes,
father?
we have produced the
I think birth certificate has been
We
given,
want
which
the
was
correction
obtained.
according to birth certificate.
Birth certificate has been obtained after the.
But the recording must have been done on the day or within a very close proximity of the birth. Because if it is in a hospital, then it is a statutory duty of the hospital to intimate.
That is correct. That is correct that within 1 week the hospital has to
Sir,
intimate
birth
the
certificate,
authority.
sir, for birth certificate, if it is obtained later on, the case is filed before the
Yes,
executive magistrate also.
Yes.
Then he directs the police to inquire and give a report. Basing on that report, municipality or NSC is directed.
There will be
to-
inquiry by the magistrate himself, where the petitioner has to examine himself and prove it.
So
that certificate
So
was
that
given.
means yes.
No, that certificate was given on 19/9/2009.
Maybe,
Whereas the
sir.
petition in the
So-
school.
Maybe, sir, but based upon the evidence which is there at the time of the birth, if there is already intimation by the hospital and the intimation shows that a girl child or a male or a boy child is born, these are the father name and the mother name, then
That was not there. That is not there.
not
Also,
there.
kindly see.
So 7.1 of the judgment.
Yes.
7.1.
Yes.
So what you are to since Annexure 1 is a public document showing the date of birth of petitioner's daughter
Yes.
as such and her parents' name so and so, the same should not have been overlooked by the authorities of the board while rejecting the petitioner's claim.
Your worship kindly, if your worship have got the records, I don't know that I can show the birth certificate that was given. That was annexed to the petition. Your worship find that was granted only on 19/9/2009. Yes, that can be corrected.
No, granted on 2000. The date of registration is 19/9/2009.
Yeah.
And when she is appearing for the class 10 examination.
She has not yet.
Not yet. Not yet.
Not yet appeared. So,
Not yet appeared.
So,
He has not yet appeared.
what is her date of birth? That is on 29/8.
29/8.
And registration is within 1 month.
Yes.
Within 20 days, the registration is given.
But you will also see the certificate.
But the certificate is issued on 14/10/2015.
Yes.
Oh, sir. There are many cases where one can apply for a certificate if the earlier certificate is lost. So when they apply for a certificate, they will give the date when they have issued this certificate. But the date of registration is of a very important factor. Had it been in a close proximity of the date of issuance of the certificate, I can appreciate what you are saying. But it appears that it is in a close proximity of the date of birth.
within 1 month. Around
20 days or something. 29 and 19, just 20 days, approximately. How can you? That means the registration was done.
The other issue is relating to the names.
Sir, name is there. Father's name is given as Parvati Raut. And the father, name is Parvati Raut. Name of the father is Bholanath. And the place of birth is SCB Medical. That's the government hospital. So how can you deny? And the mother name is a Lily Raut.
Whatever entries are there in the
Don't be so technical. After all, she's a child. Identity is a very important factor of one's life.
Affidavit is also there. What is affidavit is filed before the sworn to in before the executive magistrate.
It so happened at that point of time that the uncle don't be too technical of that. Yes. The instant intra-court appeal is filed
2/3/2024, that is written in the admission also. And father's name was also wrong. Mother's.
Lordship, item 49 was mentioned in the morning, Lordship, some precedents, Lordship. This matter is an execution appeal matter where